had about 45 minutes for a 30-minute hearing, okay? I'm gonna address your issues alleged in this document, and again, if you need more time to argue additional facts, we'll work that out. But as far as improper application of statute 322.34 as the requirements, I'm gonna find that the charging document, meaning the traffic citation, is legally sufficient, and therefore I'm going to deny demand for dismissal under number 10. We already number 11, the corpus selecti, that involves the elements of the offense. They would have to, and that's also number 12, they would have to prove each and every element of the offense as set forth in the statute and as delineated in the jury instructions. And until such time as the evidence is presented, I don't believe that there is an appropriate basis to dismiss the case. And again, it would depend on whether the state proves each and every element at trial. Okay?
Oh, yes, sir. Now, for the record, the charging function issue, because I'm a little unclear. She's charging or they're charging?
The citation, the authority to bring the case is going to be with the state attorney's office. The individual that issued the criminal citation, which they are now prosecuting, would be, is it TPD? Okay. Tampa Police Department. So the arresting agency, or the agency that observed the offense and issued the citation, would be the Tampa Police Department. However, the legal process by which that claim is litigated in court, the jurisdiction or the authority to bring that case is within the state attorney's office for this circuit. So, but that's a different issue than 11 and 12. And so again, and these all go back 11, almost every one of them, starting at 10, 11, 12, 14. They all have to address the issue of whether there's sufficient evidence presented on the record at this point to allege the crime, and I think there is. I think based on what's been filed and prepared or issued by law enforcement alleges the offense of driving license suspended with knowledge, and so the other elements, or the elements whether they can be proven or not, is a trial issue.
And without proof, it's not evidence. So.
Well, but that's what trials are for.
I just want to make that on the record. So there's actually no evidence. Nobody's providing evidence to tell that.
There is. Well, the evidence would be at this point. The evidence would be the citation and the police report. The actual trial itself, to prove whether the crime occurred or not, that would be a function of live witnesses under oath testifying, and whether the state could prove all of the elements beyond a reasonable doubt that you committed the offense. That's the process and functioning of the trial. So as to number 10, 11, 12, and 14, I'm going to deny that demand for dismissal, because I do believe that there are sufficient legal basis for this case to go forward at this point for trial. Notice of challenge to statute of motion to intervene. The state just got a copy of that today. So let me ask you one more question. You expressed any concern over the jury trial issue. I don't know if you have any other motions you want to be heard. And so what I want you to tell me is, are there other pleadings that you want to file before this case gets...
we're going to file a suppression.
Okay.
Notice for a demand for suppression.
Well, suppression is a evidentiary hearing. Right. Okay, so that's going to take some time. Let me ask you about the trial. The trial is scheduled for July the 2nd. Do you want to move the trial date, or you?
I'm not going to waive my rights. The speedy trial.
Okay. Well, and again, the April, July. Then you've got. Where are we now? June
19th.
Then here's the thing, though. You have the onus, unless you want to continue the trial. You have the onus and responsibility of raising these legal issues, not only in written form, and you've done that, and I appreciate that, in a notice of hearing, and you've done that, but also timely. In other words, these are issues that would have existed potentially at the beginning of the case, and if we don't get them addressed relatively quickly and timely, I'm not going to be able to hear them before the trial date of July the 2nd.
That's overstood. However, the reason that we're this far back is not because of me, it's because they didn't give me discovery until last Friday, Thursday or Friday. Last time I was in here.
Well, here's where we are. Today is June 19th. How many days before trial?
There are
10.
No, it's what, 11, 13? for this to get heard, we're going to need this thing to be done relatively quickly.
I need at least 5 business days.
Well, let's do this. Can you get Brenda to come in real quick?
Yes, Your Honor.
I'll see what I have that Monday.
Now, let me say this also. And I apologize for what's going on in the background. I had to put in that password because I know I have that on my other computer. So I thought that particular subscription to Adobe goes to all of them. I'll fix that later on. So I'll worry about that later. I'll be able to show you the documents I brought up. As to the suppression hearing, which he says an evidentiary hearing, that means I get an opportunity to cross-examine whomever the state's witnesses are. That could have been one of the the preeminent reasons why the state dropped the case later on, but they knew that I was aware that there was SOP within the Tampa Police Department relative to what they should have had as far as being able to prove what they were alleging. And I did have a mechanic to come in, that would have been able to come in and say, hey, listen, this BMW, I think it's my BMW at the time, is always maintained, so that wasn't an issue. I don't know, that's all speculative, so let's not get too far off into that. Let's just focus on what comes from the suppression hearing.